Dear viewers, today's topic of discussion is that the law is natural and it evolves naturally. Law, as its core, is a reflection of human civilization, its moral values, social needs, cultural patterns, and collective conscience. The idea that law is natural and evolves naturally suggests that law is not merely creation of authority or legislative power, but a product of human reason, universal moral principles, and an ongoing social transformation. This philosophical stance is deeply rooted in the natural law theory, which argues that certain rights and principles exist inherently independent of written statutes or governmental enforcement. Now, in this context, let us understand the natural basis of law. Natural law philosophy maintains that law originates from what is inherently just, reasonable, and morally right. According to thinkers like Aristotle and Cicero, law is derived from nature and human reasons rather than solely from the legislative enactment. Human beings, by virtue of being rational and social, possess an innate understanding of justice, fairness, and equity. Thus, law is not imposed externally, it arises from the ethical and rational fabric of human existence. For example, even before formal law existed, human societies operated on unwritten norms: respect for life, protection of family, and communal responsibility. These principles existed with codification, demonstrating that law precedes legislation. So the question arises as to what is historical evolution of law. Law evolves as society evolves. What was once acceptable may later be viewed as unjust, and legal systems change to reflect this shift. A notable example is the journey from permitting slavery to universally rejecting it as a violation of human dignity. Similarly, women's rights, environmental protection, and digital privacy laws emerged gradually as societies recognized new ethical standards and realities. This evolution reflects the principle that law is dynamic rather than static. It grows organically through custom, judicial decisions, social struggle, and moral progression. At this juncture, it is important to understand the role of judicial interpretation. Modern legal system continues to demonstrate the natural evolution of law through judicial reasoning. Courts often interpret constitutional rights in the context of changing societal values. The recognition of right to privacy, same-sex marriages rights, or consumer rights did not emerge through sudden legislative invention, but through interpretation of existing moral and constitutional principles. Judicial activism and the principle of natural justice, including the right to fair hearing and impartial decision, stand as proof that law develops organically to ensure fairness and protect dignity. Now let us understand the relation between law and consciousness. As society becomes more informed and interconnected, law adopts law adapts to new realities such as technological advancement, global communication, environmental threats, and human rights discourse. Law, therefore, mirrors the collective progress of humanity. It is shaped by ethical reflection, social behavior, and cultural maturity. In this sense, law is both a product and instrument of human evolution. It grows naturally as individuals and societies grow morally, intellectually, and culturally. In view of the discussions made till now, it may be concluded that the notion that law is natural and evolves naturally underscores a profound philosophical truth. Law is not merely a command, it is a living institution rooted in universal values, human nature, and societal development. As society progresses, so does its legal system, continuously refining its principle to reflect justice, morality, and human dignity. Thus, law remains both a guardian of civilization and a product of its ongoing evolution. Thank you.